Basically, there was a book in the movie that was like, if you preclude, if you say your answer, if anything different in your acceptance contains additional terms, it comes with a counteroffer, and that precluded them from accepting. So, as always,
this is after the ECC.
I know. I'm waving to the camera, so I'm just recording this. What? What? We're not. Just about a minute of it. Just a minute. Please disregard what Lindsay said off camera. Okay, so today we're going to be talking about statement of the case and invisible persuasion. And just as an aside, it's great to see all your faces. I haven't seen you in a while, and so it's great to connect again. I look forward to the oral arguments beginning today. I'm really excited for them. I've seen some really encouraging stuff on the video, and I have not distributed feedback sheets for the practice rounds because I feel that they may make you more nervous. But I will give you the scores from the practice rounds in addition to the score for the final rounds. And you'll be able to see, any growth. So I will eventually distribute those. And I will take questions about oral argument at the end of our session. We're going to end at 11:30 today, if not earlier. Okay, so statement of the case and invisible persuasion. Just to review, these are the contents of your appellate brief, and I have distributed the templates via Twin under assignment materials, appellate materials. So in your template, there is a cover page, there's a table of contents, a table of authorities, a statement of the issue, a statement of the case, standard overview, argument, and conclusion, and signature page. The only things we haven't covered here, we haven't covered the cover page. We haven't covered the table of contents and table of authorities. Those are pretty self-explanatory. If you have questions about the template, I can take those at the end. We haven't covered statement of the case and the conclusion. Let me just start with this, and then the rest of this class is going to be focused on statement of the case.
The statement of issue and standard of review,
yeah.
We did those before we turned in the draft and the outline.
Mm-hmm.
Did we get feedback on those?
I don't think you did, but I can ask Myfe and Tess to take a look at them. Okay. I did look at them as they came in, and I found that there were some legal conclusions in the back part of the statements of the issue. So some students said, when they have an interactive website. Well, you can't say when they have an interactive website because that's turning the conclusion that you have to draw, that you have to convince your reader of, into a fact by putting it in the fact part. So it's circular logic if you do that. The same thing if you say, when it directly targets, right, the Massachusetts. You can't say directly targets. What you have to focus on are the facts that you use to prove that it directly targets and include that in this statement of the issue. That was the major feedback that I have on statement of the issue, but I'll ask my FA and Tess to take a look at the statements of the issue. The conclusion is a very simple, almost boilerplate thing. For the foregoing reasons, this court should affirm the trial court's ruling. Or for the foregoing reasons, this court should reverse the trial court's ruling. You do have to state for LO7, you do have to state reverse at this point. Now, what that means is that at the end of the argument, you will have a conclusion. Remember that your conclusions have to work back out. Just as in the beginning of the umbrella, your rules worked in, the conclusions have to work back out. So where you need to end with the argument is that it did not comport with the Constitution and the long-arm statute, or it did comport with the Constitution and long-arm statute. that would lead to this conclusion, which is, for the foregoing reasons, this court should reverse or affirm. Okay, but there has to be a dovetailing between the last sentence of the argument and the conclusion. It should just naturally lead to the affirm or reverse decision. But you only really get there, again, if you show that it meets or doesn't meet constitutional and long-arm muster. Okay, so make sure that happens in the end of the argument and then leads to the conclusion. Questions about that? Okay, statement of the case. So many people know this as the statement of facts. So it informs the court of the relevant facts and procedural background information of the case. The relevant facts and the procedural background. That's the difference between statement of facts and statement of the case. Statement of the case tends to have more procedure than statement of facts. Okay. I'll show you some examples. The primary purpose is to inform. Primary purpose. The secondary purpose, the secondary covert purpose is to persuade. It must be invisible because otherwise your court will not accept it. So it has to appear even-handed and fair. Now, how do you do this invisible persuasion without banging the head over the, banging your brief over the reader's head? So make sure that it never contains conclusions of law. In other words, for this matter, it should not state websites interactive. It should not state direct targeting. It should not even say geared towards the forum state. There should be no inferences drawn that are overtly favorable to your side. So this gets a little tricky when it comes to the topic sentences in the paragraphs, because each paragraph needs to have a topic sentence in the statement of the case. So, like, let's say you're doing a paragraph about the website, and you want to make it about the interactive features of the website. You can't say in the topic sentence, Ciarvar Falla's or Appellee's interactive website contains the following features, right? Again, that's a conclusion, that's an inference. We tend to draw those inferences when we're using topic sentences, but be careful with them. Okay, so that will be a tricky point in the statement of the case. So describe the facts and place the facts in ways that support your theory of the appeal. And your theory of the appeal should implicitly come through in the statement of the case. So here are some don'ts. Don't include untruthful or characterized facts. Okay, that's a big one, characterizing facts.
Give an example.
Yeah. Well, an interactive website is one that comes to mind. The live help feature allowed the user to develop relationships. Actually, they say develop relationships when it comes to something else, but allow the user to develop relationships with the company. They say develop relationships with respect to the emails, but they don't say it with respect to the website. And so it would be characterizing live help feature to say help them develop relationships, because you're drawing an inference, you're taking a step back, and you're saying this is what they're doing. I'm trying to think of another one. What about the Puffin poster? The Puffin poster is only in its beginning stages. Puffin poster program is only in the beginning stages. Well, it doesn't say it's only in the beginning stages. That's characterizing the facts. Okay, that is sort of drawing a conclusion or drawing an inference from the facts. So just be mindful of that. You shouldn't have to use signals when you cite to the record, which I'll cover, because there shouldn't be no inferences drawn. A signal is needed when you are drawing an inference to a certain extent from the authority. But you shouldn't need that. Okay, so there shouldn't be signals in your citations to the record. I already said do not talk about law. Do not include facts that were excluded from the record, for example, by stipulation. So that Oryx O'Brien was from Massachusetts. No. That Oryx O'Brien had experience with the tourism industry. I don't know if you can say Massachusetts. I don't think you can. I think LO8 would say you can. I mean, is that central to your argument? It really is?
I think during oral argument.
It could tip the scales. So study the stipulation. Stipulation says you cannot use the fact of his residency in previous residency as Massachusetts against them.
Right, but he still has contact. I'm not saying he's a resident. Like I've been.
Do you know that? That's a characterization of the record.
But he was in the tourist company. So I'm sure.
Right, but see, there's an inference that you're drawing. You're drawing an inference by saying that he has contacts in Massachusetts. The record doesn't say that. You're drawing an inference. So be mindful, like that. This is telling me that that you're going to sort of veer into inferential territory in your statement of the case. Be really careful. Because he has experience in an analogous tourism industry, in tourist company, duck tours or goose tours. Sorry, goose tours. So his experience may be, germane to Deborah Follow. Yes.
I thought it was in the record. I'm confused as to what constitutes being in the record or not. Because we wouldn't be able to talk about this if it weren't in the record.
Like what?
Like the fact that he was from Massachusetts. Because we didn't want
He is from Massachusetts, yes. But after having reviewed the record, stipulated that they cannot use the fact that he's in Massachusetts against the other side. So putting it in the record, putting it in your narrative of the facts is kind of off. Is
a deal with LO8.
Right. This is a deal with LO8. So it can't be part of your narrative because it's to persuade the reader, right? You can't try to persuade the reader with Oryx O'Brien's residency.
Wait, okay, where's
It's in the assignment sheet.
I thought we're not.
No, you made there were two stipulations. The stipulated as to relatedness, and in exchange, you stipulated the fact of Oryx O'Brien's residency in Massachusetts is immaterial for the personal jurisdiction analysis. That is Oryx O'Brien.
Oh.
I don't recall that one. Does anyone else?
There's a travel blogger from Holyoke.
That's not.
Right.
No.
I only recall
So there's 3 employees plus Oric, right?
That's what I think.
Yeah, and so the Oric is the one who's he used to be the owner, he used to work at Goose.
Goose Tours, yeah, and he went to MIT.
And then when they were expanding,
No, I know that, but there was that.
I don't know. Find a place in the record about that. I don't recall writing Newton, Mass, but maybe I did. I'm confused. So check that.
Wait, is there a deposition?
There's no deposition.
No, it's like when you're arguing. Actually, I'll tell you after. I don't want to say it on camera.
Okay.
Recorded.
All right. This is just a little speed bump. Let's move on. But do check about the Newton Mass. That would be helpful. So remember your ethical duties. A lawyer shall not knowingly make a false statement of fact. So resist the temptation to overtly persuade and bend it. Okay. So how do we well, before we get to how we persuade invisibly, here's some guidance on citations to the record. The Blue Book's method of citing to record documents is very confusing, and it's on page 24 to 26, just in case you want some extra reading material. But it does happen to say that it is customary to use R period at blank, at page, when citing to appellate records. So I glommed onto that, and that's how we're going to cite to the record. R period blank. I posted a correctly paginated version of the record on Twen. So this is, and do not use parentheses like you'll see in the Blue Book. It does have a period at the end. Don't use signals, and use a line reference. So there are line references on the left side of some documents. If your document contains line references, use the line references as well. And this is how it's all done. Here's just an example that sort of carried through this PowerPoint. While Mr. Joyner testified that he knew Aaron had been seriously injured by the fall at the time he heard the crash, R at 5, so this is an intervening citation clause. He stopped on the 8th floor hoping his daughter was there. R period at 6, and then separating the reference by a semicolon 8. So this is on page 6 and page 8. Notice that 5 is not included here, like 5, 6, 8, because this part refers to 5, and this part refers to 6, 8. It wouldn't be proper to include this at the end. After discovering no trace of his daughter on the 8th floor, he descended even faster to the bottom. R period 4 and 6 to 7, page spanning. On the ground floor, Mr. Joyner saw the aftermath. Record at page 29, line 20 through 24. Page 29 and 26. So referring to 3, 5, 4, several different references. So these are line references. Make sure that you include them. You can do a page span or a line span. And if it's the same page, you still have to repeat the page. Okay, questions?
So we would not put these in our application.
No, you don't put this in the argument. Good point. You only put this in the statement of the case. If you prove where everything comes from in the statement of the case, you should not have to direct the reader to the record in the argument, unless you want to make a point, you want to re-emphasize something that maybe the reader won't believe, right? Like the reader's like, I don't remember that from the, and you could direct them to the record in the argument, possibly. Other questions about citations? Yeah.
So for the second one, you have last one at the 29, and then why did you do 29 twice?
So this is still page 29, but it's line 26. So it says separate references with semicolons. I don't think it's proper to do 20 to 24, comma 26.
Okay.
Because it does say separate references with semicolons. So, but if you did that, I wouldn't fault you for it. Just be consistent in whatever you do. Okay. Other questions? So this should save you space as opposed to doing what Blue Book is otherwise telling you to do, which is cite the names of the documents. Plaintiffs' requests for interrogatories or whatever. It's long and laborious. Okay. So, persuading invisibly. So, generally, a story has three possible organizations. Chronological, so like a play-by-play, topical, or a combination of both. You can persuade through your organization. For example, if the precipitating event is good for you, maybe begin with a precipitating event and start chronologically, right? If a topical organization is stronger for you, for example, beginning with a description of the parties and your party in particular, then maybe you begin with a topical. If there's an important precipitating event that happens, then it might be appropriate to go to chronological. So that's the combination, topical, chronological. But it depends on which side you're on. And I'll show you an example of this. So that's a large scale persuasive, like invisible persuasion technique. Small scale, you can persuade through your placement of the facts in the paragraph structure, the sentence structure, and the order of the facts in the narrative. So just as an intro to storytelling, here's a story that you might be familiar with. Once upon a time, there was a dear little girl who was loved by everyone who looked at her, but most of all by her grandmother, and there was nothing that she would not have given to the child. Once she gave her a little cap of red velvet, which suited her so well that she would never wear anything else, so she was always called Little Red Cap. One day her mother said to her, "Come, Little Red Cap, here's a piece of cake and a bottle of wine. Take them to your grandmother. She is ill and weak, and they will do her good. Set up before it gets hot, and when you are going, walk nicely and quietly, and do not run off the path, or you may fall and break the bottle, and then your grandmother will get nothing. And when you go into her room, don't forget to say good morning in the morning before you do. I will take great care," said Little Red Cap to her mother. Okay, so what's notable about the beginning of this? Well, first of all, what story is it? Yeah, it's Little Red Riding Hood. This is the Grimme's version, the original Grimme. So what's notable about the way things unfold here at the beginning that you might be able to impart to yours? What's the organization?
Like,
Okay, so but saying there was a dear little girl doesn't really seem like you're giving a timeline of events, which is a chronological organization. So what is that part? Well, certainly it is pathos because you're trying to create. Well, the Grimm brothers are trying to create a protagonist. Okay, so that is an element of classic storytelling, like having protagonists and antagonists. And that sort of plays into the pathos of the whole thing. So I think that's a good point to make. But in terms of the organizational structure, we have topical, we have chronological, and we have a combo. So this isn't chronological, so it's probably topical. So we have a description of the protagonist. Okay. And what she was wearing. So this is the setup. We generally include, in storytelling, we generally talk about the protagonist first. We're not talking about the wolf yet, right? The wolf comes in later. So the protagonist happens at the beginning. It's favorable in the story to begin with this protagonist. Now she gets eaten at the end and dies, but whatever. So then comes the chronological. One day, ... Okay. And that's the precipitating event. So this is a topical chronological organization. We need the topical to get us to care about the organization and what happens to her. Okay. So let that imbue the way you construct your statement of facts. It's very important in personal jurisdiction that the reader understand the parties, where they're from, maybe the types of contacts before the precipitating event, which probably is may not be towards the end, but the precipitating event is what? What caused this whole thing to kick off? The trademark infringement. So maybe when they started using the mark, right, that you might be able to create a chronology from that. The timeline of events may help you create a chronology, but you're not going to get the reader to really care about the chronology until you set up the parties or this topical organization. My sense is that you'll also want to set up the contacts somehow. outside of chronology, because otherwise it could get confusing. If you're saying, you know, in 2012 they bought this website, in 2014 they converted it to English language. I don't know if that's true. And in 2016 they created a live help feature. The live help features, blah, 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 right? It's a little bit. You have all these intervening topical things that just don't really work out. Yeah.
Characterizing facts from the defendant's own incarnatories that are characterizing, like,
Yeah.
they say, like, we wanted to expand to the United States.
Yes.
That's like,
Yes, you should quote. You should quote those segments. Don't quote whole big passages, but you should quote the language, incorporate that into your prose. If they say it, it's fair game. Okay. So that might be a good thing for some topic sentences, actually. If you wanted to say the defendant has the defendant in creating the website and as long as it's supported by the record, they wanted to expand to the U.S. Then you could talk about the expansion efforts, right? But otherwise, I wouldn't do it. Okay. So just remember, a story has a beginning, a middle, and an end. The end is kind of tricky. The end, you need to bring the reader seamlessly to the argument, right? Or to the standard of review, which happens next. So you've got to bring the reader somewhere in the statement of facts, probably at the end, but not, probably at the end, up to the appeal. Because then we're here, this is front of the court, right? And here's the standard of review and appeal. So there has to be some sort of dovetailing between the statement of facts and the standard of review, which is the next section. I would say many stories, if not most, have a topical chronological organization, protagonist, antagonist, and a precipitating event. So the reader's attention is highest at the beginning, and you should grab the reader at the beginning, but not in an overtly persuasive way. Okay. And it's also a good idea to end with a punch. Again, not in an overtly persuasive way. A notable fact, including a notable fact at the end, could be helpful. Just do it with the facts that you choose. So you could incorporate procedural history at the beginning or end or both, depending on whether it's favorable to you. So I would imagine that the other side is going to include a great deal of procedural, like Law Office 8, it's going to include a great deal of information about the decision below. Are the particulars of the decision below, the trial court's decision, the particulars beyond, more in depth than the ultimate holding? Is that relevant? Is that legally significant in light of the standard of review? No. The standard is de novo. Without regard to the trial court's decision, this court will draw an independent conclusion. The holding is legally significant. What the court found, that they found or didn't find personal jurisdiction, is legally significant. But the reasoning, it may not be legally significant here. So you, as Law Office 7, may not choose to include detailed information about the court's reasoning. Law Office 8 may include detailed information about the court's reasoning. So what I'm thinking is, like, what the court found on purposeful availment. They found that there was not something more in the website. Do you need to include that, I ask you? So for Law Office 7. I don't think it's legally significant, given the standard of review. But it may be emotionally significant for Law Office 8 to include. So I would imagine Law Office 8 would include it. And I would imagine that it's either the beginning or end. Let me show you an example of this. I wrote a little sample opening on the EMTALA issue. And I'll see if you can guess who this advocate represents. The beginning of the statement of the case. This case comes to the Ninth Circuit based upon a grant of summary judgment in favor of Mission Angeles Central Hospital, Match, in the U.S. District Court for the Southern District of California. The original complaint against Match was filed by the mother and sister of an emergency room visitor and alleged that Match's ER staff had violated the Emergency Medical Treatment and Labor Act, EMTALA. On February 15, 2018, Match moved for summary judgment pursuant to Federal Rule of Civil Procedure 56. The Honorable Percy Miller, U.S. District Judge, granted Match's motion based upon the undisputed facts as a matter of law. The district court determined that no reasonable jury could find Match liable for violating its duty to adequately screen the emergency room visitor. The district court reasoned that there was no evidence in the record plausibly suggesting that the visitor's screening was cursory or disparate in nature. On March 1st, 2018, the district court's decision was appealed. Appellate Match is a university-affiliated hospital operating in Mission Angeles, California, a medium to low-income suburb of Los Angeles. Match is consistently rated one of California's most patient-centered hospitals. The emergency room at Match sees thousands of patients every year. Okay, ... Now, this is organized with subheadings or headings. You can do this in your statement of the case if there are discrete parts to your statement, to your factual narrative. For example, Match's ER triage procedures, H1N1 screening policy, and staffing protocols. This begins with this. In early 2017, an outbreak of H1N1 virus inundated emergency rooms throughout Southern California, and Match developed and institutionalized a formal screening protocol for H1N1. So that would, I would imagine, that would continue on to talk about the protocols and the procedures in the ER. That's necessary to get us to get the reader to understanding what happened when the chronology occurs. And then B, events on August 1st, 2018, which is when Carlos came to the ER. So who do you represent here? Match. And how do you know that?
Very favorable.
It is, but are they using overtly is the author using overtly persuasive? No. It's the placement. First, it's the placement of the procedural history at the beginning, which is good for Match. It's the deep level of detail in the procedural history. The standard of review on this would be de novo. So this adequate screening and disparate screening is not really relevant, but it's emotionally significant for the other side. So where is the description of the opposing party? What the name of the opposing party? Yeah, there is none. I would imagine it comes down here. So that's significant. This is burying the other description of the other side, so you don't really care about them as much in the narrative, in the timeline. Or just, this would be like a topical chronological thing. And all of this is about Match. Okay. About how thorough the procedures were, blah, blah, blah. Okay. A lot of this stuff is pathos. Match is consistently rated one of California's most patient, by who? I mean, as long as the record says it, right, you're fine. Now, consistently rated, if the record said they were rated best patient-centered hospital in 2016, 2018, and 2012, and 2014, right? You still can't say consistently rated unless it says consistently rated in the record, or even if it every year, I would not say consistently rated. It's still a characterization of the facts. So be really careful. Yeah.
Does that include the complaint?
Well, so what would you want to say from the complaint as an example? Yeah. Does it say excellent business reputation? Yeah. When in doubt, use the language that they actually use. If it's coming from someone at Sierra Fala, if it's helpful. When it's not helpful, paraphrase. But be careful about the paraphrase that it's like one-to-one. It's not a different, there's no inferential step. Okay. So going back, so this sort of just re-emphasizes the point that I made with EMTALA. This is a problem involving a social worker for home elder care and against a patient, or a patient against the social worker. So the side representing the social worker says home elder care, that's the party they represent, is a private nonprofit corporation with a staff of geriatric social workers who provide services to help their elderly clients with day-to-day activities. Volunteers assist with some services. Available services include shopping, transportation, assistance, personal finances. The social workers also serve as liaisons with clients and attorneys. And then the patient side is Roger Nelson is a 78-year-old and a widower. He is in declining health because of diabetes. Contemplating a time when his condition might worsen, when he would become incapacitated, Mr. Nelson set out to arrange his personal finances as he wished. Among other steps, Mr. Nelson wrote a living will. Unfortunately, Mr. Nelson initially turned to defendant home elder care to prepare his living will. This is not perfect. It does persuade through the organization of the rollout of the parties. Is there anything you don't love here in this one? Yeah.
Unfortunately.
Yeah, the unfortunately is problematic. Really problematic. Persuasive. Okay, so be careful about that. Be careful about using, like, that's a characterization. Unfortunately, unfortunately, Sierra Farfalla, right? It just doesn't. It's not going to work. So keep that in mind. So some other large-scale techniques. Let's see. So I'll just read this. Home elder care is a private nonprofit corporation with a staff of geriatric social workers who provide services to help other elder clients with day-to-day activities. I already read this. They include this, that, and the other. And then the patient's description of that company later on in their statement of the facts is home elder care is staffed by social workers. These social workers are not lawyers. These social workers do not have law degrees. These social workers have not been admitted to practice law in Minnesota or anywhere else. What do you think of that? It's persuasive insofar as you have these short sentences all strung together, right? This is true, this is true, this is true, and this is true. Maybe if we had like an intervening, more complex sentence, it would be a little less overtly persuasive. Or if we put a bad fact in there and somewhere in the middle, or like a slightly unfavorable fact somewhere in there, it might be less overtly persuasive. But this is kind of like the way you'd write it in the argument section. So if in the middle of writing the statement of the case, if you're sort of feeling like, I'm on a roll here, like I'm going to put this in my argument. I mean, that's not what you want to be doing. Okay. But you should be thinking about like invisibly persuading at all times. Now that's large scale techniques. So we have the organization, the large scale organization, the placement of the description of the parties, the level of depth you give to the description of the parties. Small scale techniques use active verb choices if it helps you. Use passive to de-emphasize the actor. So here's an example. Dr. Safe diagnosed Mr. Hernandez using differential diagnosis. Who did it? Dr. Safe. The subject appears before the verb. Dr. Safe diagnosed. But if you said the decedent was diagnosed by differential diagnosis, that de-emphasizes the person diagnosing So if you represented much, maybe you want to do that because you don't want to place emphasis on that a doctor, that it was done by Dr. Safe, maybe. That's an example. Another classic example of this is if you represented police who shot someone, you wouldn't say police shot Rick, you would say Rick was shot. Okay. So that's active versus passive verbs. That's a small scale technique. So another small scale technique. Emphasize favorable facts in a short sentence. Going back to this one, favorable facts in short sentences. And unfavorable facts in a longer sentence. So here's an example from Untitled. The decedent who had, anyway you hear decedent, you represent that. The decedent who had been personally cleared for discharge by the attending physician later had a stroke. The other side might say, Carlos suffered a stroke upon discharge. Right? And then emphasize favorable facts with detail, de-emphasize unfavorable facts by providing less detail to the extent that they're legally insignificant. But if the detail is legally significant, you have to include it. Okay. So, for example, this involves the procedure. The U.S. District Court granted summary judgment in favor of Match, finding that no reasonable jury could find that ER staff conducted a cursory adjustment screening. The other side would probably say the trial court ruled against the Hernandez's claim of an EMTALA screening violation. Questions about small-scale techniques? So this is longer sentences, shorter sentences, more detail, less detail. Other persuasive techniques. Humanize the client, and I've covered this before. So use their actual name throughout. And use generic labels for the opposing party. In that EMTALA example, I used the mother and sister of a deceased emergency room visitor, not patient actually, but visitor, right? And you might just refer to them as appellants here. Be really careful about adjectives and adverbs. Really careful. You should persuade with verbs and vivid verbs and vivid nouns. So this is from a problem I once did involving an elevator that fell and a negligent infliction of emotional distress claim. So the side representing the decedent would say, the elevator plunged down the elevator shaft instead of fell. The coroner testified that the force of the impact shattered instead of broke Aaron's spine. But be careful that you're not taking it too far. If it's true that it shattered her spine, right? Maybe you have the x-rays, maybe there's a lot of the fragments, right? Then you can say shattered. But it's really got to be a close paraphrase or synonym. Juxtapose favorable and unfavorable facts, but favorable facts in independent clauses and unfavorable in dependent clauses. I cover this all the time. So this is what you should be doing in the argument section to de-emphasize and get over the little road bumps or speed bumps that are the other side's good facts. Okay, so although there is a live help feature, the law office 8 might say, but you have to really be careful with this technique in the statement of the case. I would not do this all the time in the statement of the case. Too many of this flags overt persuasion. Although Mr. Joyner was hospitalized after the accident, he returned to work 3 months later and is now the foster parent of a 16-year-old girl, right? That's kind of overtly persuasive. So just be careful about the dependent-independent clause. If you do it, try to do it infrequently. Yeah.
You said use their names. For CCC, do we have use the names of the people who work at CCC?
No, I don't think you need to. I don't think you need to use their names. Well, you don't. You mean Sierra Fala? Because there really aren't that many.
Yeah, that's what I was thinking.
There aren't really that many title like names for people at CCC. But for Sierra Fala, for you, I don't think it's necessary. For Law Office 7, I don't think it's necessary to include people's names. I don't even think it's necessary for Law Office 8 to include the people's names, unless you wanted to show that their names, which are classically Icelandic, unless that's favorable to them, right? Yeah.
And with that, throughout the brief, should appellant.
So if the title, if in the sentence, in the context of the sentence, you need to know that they were the original defendant, then include defendant appellant. If it's not necessary, otherwise refer to them as appellant. So, but it kind of depends on the context. I don't think there's going to be a time in the statement of the case when you just refer to them as defendant.
Sorry, beyond just a statement of the case.
No, I think the same holds true.
Appellant.
So I would, as a default, refer to them as appellant. The other side would refer to you as you're not referring to yourself as appellant.
Oh yeah, they're appellees. Sorry.
Right, you're appellee.
Okay, that's it.
Right.
My bad.
Yeah.
Appellee.
Yeah.
On that, what about for oral argument?
Well, we're on appeal. We're on appeal. They are the appellee.
So say appellate.
I mean, you could say, it's tomato, tomato. You can say appellee, you could say appellee. I'm not going to fault you for either. Yeah.
Really quick, you also said when you say the defendant, you capitalize the D.
When you're referring to our defendant,
Uh-huh.
our plaintiff, our court, our circuit, then you capitalize.
Okay, and you capitalize the as well, or no?
Okay. And one of the final, no, there's a few more, but persuasive techniques interrupt negative inferences that can be drawn from unfavorable facts. So if there's an unfavorable fact that the reader might think, that might mean that they're liable, right? Try to interrupt that with an intervening good fact. So the example is, while Mrs. Davidson testified that she knew Lily had been seriously injured by the water slide collapse at the time she heard the crash, which might mean that she has a claim. She did not immediately ascend Mammoth Slide Hill. She waited until the attendant confirmed that someone was in the slide. So suggesting that she didn't know, right? But not saying that. Maintain your credibility by avoiding conclusions, inferences, and arguments. So this first example includes an argument. The dispatcher lied to the caller by telling her that officers were on the way to help her. Okay, so the record doesn't state she lied. The record states what she stated. So to say that she lied, which is what you're trying to prove in this particular problem, is an inference, is a conclusion, is argument. But you could just say, even though the dispatcher's computer showed that no units were responding to the broadcast, she told the caller that someone was on the way to help you. The reader can think, oh, she lied, right? But you're not saying that. Questions? Can you think of an example from our matter that you might do this for? Yeah.
They're not actually using the trademark. Something similar.
Okay. So, what would you say? Even though they're being sued for trademark infringement?
They're using
Oh.
essentially similar to.
Okay. Well, you can't say substantially similar. Can't say substantially similar because that's the standard for trademark infringement. Yes. You could say that because that's in the complaint. Okay. But you can't say it is substantially similar. Okay. So these are persuasive techniques that you can employ. It's sort of like your arsenal. I think the ultimate persuasive technique is the selection of the facts that you include. But being mindful that you always have to include all legally significant facts, including legally significant adverse facts. All. You have 4 pages for the statement of the case, but you may use any amount of room that you save to bump all. There doesn't have to be a page separating the parts. So you can bump up all of the headings for the parts and add space to your argument if you don't use all 4 pages. And not all the facts are relevant here. So we're going to go through. So I'm going to go through some facts now from this case, and you tell me, is it necessary? Is it favorable? Okay. Is it necessary? Is it favorable? Now, it's only LO7 here, so LO8, I want you also to take a look at these facts and tell me think to yourself, whether they're necessary and favorable. Okay, first, DCC subsidiary is Title Tours, Inc., based in Cape Cod. Is it necessary?
I'd say it's necessary because they're title tours.
So Title Tours is not an appellant. It's a subsidiary that was part of the original lawsuit, but appellant CCC filed the appeal. There aren't multiple appellants.
Okay, so it's only
CCC in the appeal. So, but that being said, I mean, that aside, is this relevant?
Are you asking me if it's relevant or if it's not?
Well, what's relevant would be necessary.
Okay, then yeah, I would say it.
So, yeah, and why is it necessary?
Well, the entire. It looks like the title tours.
Right. And you need to include, well, we'll get to this in a second, but the literal translation of their Icelandic name is Title Tours and Adventures. It's relevant that this is Title Tours. Okay. So you would need to include, it is necessary, it is legally significant for the personal jurisdiction matter. And it's probably emotionally significant for you because then you show the association between the two. Okay, with sense of fairness in the judge. Okay, next. Scarborough Fala is a small family-owned wildlife and ecotourism company operating whale-watching tours in Iceland. Yes?
For LO7,
Mhm.
I think we should just say they are maybe operating whale-watching tours in Iceland. Small family-owned.
So operating whale-watching tours in Iceland, does it say wildlife and ecotourism company anywhere on the record?
Yeah.
It does. Is it legally significant for LO7, for either side, that they are a ecotourism and wildlife company? It is.
I
Why?
would say it is because I don't know eco, but
They're a tourism company. But I don't know about the this is pathos.
Yeah.
This is good for LO7 to include because, they're do-gooders. LO8. They're do-gooders, right? So, but the fact that they're an eco-tourism company is not legally significant. That they are a tourism company, sure. I might not call them if I represented you, I probably wouldn't call them a tourism company. Call them a whale-watching tour, like whale-watching excursion. operating whale watching excursions. And small family-owned wildlife. Small family-owned. Is the fact that they're small in the record? Does it not say that anywhere?
I don't think it says their size anywhere.
Okay.
Right?
It says that they have an X number of employees.
Okay. So is the number of employees legally significant?
For them, for LO8, I think I feel like we would want to down.
I think legal significance spans LOs. It's either legally significant, it's either not legally significant, or it's legally significant.
It doesn't. I'm thinking, like, I remember just thinking about these new small businesses.
Mm-hmm.
Some other companies file under. The idea that there's small business, but our idea of what a small business.
They have 3 employees.
Yeah, but I wouldn't necessarily call them I would describe them as a national corporation with international reach. But that's my own argument.
Right.
I think.
Be careful about that international reach part. Use the facts. So, I mean, I think I get it. I get what you're saying. If they are calling it a small family-owned business, if the owner is calling it a small family-owned business, I think the fact that it's small, the size of the company is legally significant. Because do they have the resources to expand, right? It could be relevant for the expansion efforts. The other side will definitely want to include it because it supports it supports their theory of the case that they could not have expanded and targeted Massachusetts in particular.
So if I wrote that Sergeant Paula is a tourism company that is, like, I believe in the record states that they describe themselves as Iceland's premier whale watching. Iceland. What if I'm trying to depict them as a?
So the fact that they're the premier whale watching, you have to ask: is the fact that they're the premier, assuming that's true, because we have to, like, for the argument, assume that's true. Assuming that they are the premier whale watching company, if they were number 2, if they were number 3 in Iceland, would it matter for whether they directly targeted Massachusetts? So tangentially. I mean, you could make the argument. You could always make the argument that it does. But could it directly affect the direct targeting analysis?
It could.
How?
Because purposeful availment in the First Circuit, they told them something as such. So, at least for the voluntariness aspect under Sawtell.
Okay.
So we would want them to depict them as a national corporation.
Okay. Rachel?
Okay, but you can be a national corporation with number 1.
Right.
Mayor, I wouldn't want to make that argument because then you can come back and say, oh, well, the facts indicate are actually XYZ, you have these data are not number 1. That destroys our argument.
Right. I just don't think the fact of number 1 versus number 3 is legally tethered, right, to the analysis.
But could we at least, is there a relation between the size of the company and which?
Yeah, but the fact that they're number 1 or number 1, 2, or 3 isn't a reflection on the size of the company. There's no, like, that doesn't necessarily, there's no correlation there. It's just that they're the best or they're not the best. They could be a small company or a large company, right? Doesn't matter. I mean, like, Dell could be ahead of Microsoft. I mean, it doesn't necessarily mean that one company is bigger than the other, right? Okay, I gotta keep going because there are a bunch of these. DCC owns the trademarks Title Tours and Title Tours Inc. and uses them regularly. So, would members of LO8 want to include this? I mean, it's not LO8. It's not favorable to them. Is it legally significant to the personal jurisdiction analysis? I'm not talking about the trademark analysis. They own the trademark. CCC owns the trademark to Title Tours and Title Tours Inc. and uses them regularly. I don't think this use regularly is necessarily legally significant. It might be if you were doing a relatedness analysis, but you're not. So I don't think this part's legally significant, but I think it might be emotionally significant that you might want to include it. One side might want to include it. Okay. I picked the trickier of the facts. Oops. Unfavorable og Adventure is Appellee's Icelandic name. Its literal translation from Icelandic to English is Title Tours and Adventures. Legally significant. I don't know if I represented LO7, I probably wouldn't say literal translation, right? I might say translated, it means this, right? I don't know about literal translation. But the actual name and its translation is legally significant. The analysis. Unfavorable also owns and operates Tidal Inn, an all-Airstream caravan motel located a short distance from Old Harbor. Is it legally significant? No. Why? Okay, here's a hypothetical practice for oral argument. Let's imagine that Tidal Inn was advertised on the Boston to Iceland leg of the flight. Would this then be relevant? Legally significant? It would. I mean, because that's showing like a more direct targeting, so you'd have to probably provide a description. But I don't think the all Airstream caravan motel, I mean, that's just, I mean, it's like trying to tell the reader, yeah, it's really cool. Like, but it's not legally significant that there's an all Airstream caravan motel. Yeah. Sure.
You can't really gauge the importance of the content.
But does the fact that they own a hotel in Iceland, is that legally significant for the purposeful availment or reasonableness argument?
Legally significant for like content.
So you would call it a necessary background fact. So there are three types of facts. There's legally significant fact. There's necessary background fact. There's irrelevant fact. Okay. And there's emotionally significant fact, or four. Okay. So you want to include the legally significant facts, the core emotionally significant facts that are just really helpful to you but not legally significant, and the necessary background facts. Those are things like the procedure, but I don't see the fact that they own a hotel except perhaps in the reasonableness argument for LO8 to show that they are spread thin, as it is, possibly. So, it's an option. Okay. Visitors to Unfavorable's website must click on the Icelandic language version in order to change the website's language from English to Icelandic.
I'm just confused.
Yeah.
That would indicate.
Oh, because they have 3 employees and they operate a hotel? I mean, I don't know.
But that would be an inference.
As it would. Right.
Also, yeah, in fact, it doesn't, at least I really found that it says building.
I don't think that. I mean, I think they have a few. Does it say anything in the record how many they have?
I did a word search.
Okay.
Because
Okay.
there's 5 of them where
Yeah, I think there might be more than 3 total, but I don't think it ever says we have set X employees. Hmm.
that if they
Hmm.
they must
Oh, so you're saying it's emotionally significant because it shows that they have resources. It shows that they have investment. It shows that they have multiple revenue streams. Sure. In that sense, it could be legally significant because it could factor into reasonableness. Possible. So this is the gray area. Like, I don't think there's an answer. Like, I don't think there's an answer to this one about the hotel. If it comes up in your analysis, it surely has to be in the statement of the case. So that's one way to test, and vice versa. So if it's in the statement of the case, if it's legally significant, it should be in your analysis. Okay, keep going. Visitors to Unfavorable's website must click on the Icelandic version in order to change the website's language from English to Icelandic. Is it legally significant? The fact that you have to go and click, make it Icelandic. Right.
It shows that they're
Sure. They're prioritizing those who speak English. I think there's a strong, that's a good argument, right? It doesn't get us to directly targeting Massachusetts. But the LO8 will zealously include other facts around it, right? That would suggest a targeting of Massachusetts without actually saying that. But I do think it's, I mean, I wouldn't say like they must click on, like, how about the default is English, right? For LS7. Unfavorable has never offered anything for sale through its website and operates a cash-only business. Legally significant? Legally significant. Not good for you. But it's got to be in there somewhere. I wouldn't put them together. I wouldn't put them close together. I would probably put them further apart and somewhere in the middle of the analysis, in the middle of a paragraph, in the middle of the statement of facts, or statement of the case, and in the middle of a sentence. Yeah, you've got to figure out a way to talk about, LS7 has got to figure out a way to talk about the lack of sales and the cash-only nature. I might not call it cash-only. What would you call it? Yeah, it doesn't say cash, like, but I do think in-person is appropriate. You could say non-credit, I suppose. Unfavorable has had sporadic email exchanges with 2 travel agents located in Massachusetts with whom it is developing relationships, quote unquote. These are quotations from the record. Yeah. How about the fact of quoting? Sporadic email exchanges. The fact that they say it is kind of legally significant. You have to take, in the analysis, you have to take the facts as true. Although that's a characterization. You don't really need to, like...
What is sporadic?
Yeah, what is sporadic? I personally, if I represented LS7, would include this.
What about the sporadic? Is that relevant? Would I have to include sporadic? Or can I just say has had...
From time to time. I mean, I would say, are there dates about when they? No, there weren't dates.
Could I just leave that out completely and just say?
Is there a number in the record? I can't remember every email exchanges. Yeah. I don't know if the sporadic is legally significant, but I do think developing relationships is legally significant. Sporadic would certainly be emotionally significant for the other side. The first year that CR Varfala advertised on Wowza flights, the advertisements appeared on the airlines New York, Boston, London, and Paris routes.
I want to say, I think.
So the reason you'd have to is why?
It's legally
Why?
because well, for the other side, it might show.
Right, and the fact that they were in English when they did that. I mean, it's not just Boston that they're targeting. It's New York, it's London, which is also English speaking. Okay, so like, I do think it's legally significant. Yes. Well, it's in 2013. I have the record in front of me. So is that what it says?
It says, Airways Fancy Flights magazine.
Okay.
And they didn't start flying.
Okay. So the average. So they started with Boston. Is that what you're saying?
Yeah,
Okay. Okay. Sorry about that. So they started only with Boston, and then they went to New York. Okay. Then that's very legally significant. So I would include that. Good knowledge of the record. Better knowledge than one of the judges. Who created the problem? Since 2016, the Icelandic Tourism Board requested and received flyers from 10 Icelandic companies, including CR Varfala. Is it legally significant? Why?
Because it shows for the foreseeability aspect, a continuing relationship.
So the since 2016 part, sure. But what about the request and receive flyers from 10 Icelandic companies?
Tours because they knew they wanted to expand into the U.S. So they were like hand selected by this tourism board because they knew they wanted to get into the U.S.
Yeah, and I think that the 10 would be favorable to you, LO7, because if you're arguing that it would be favorable to LO8. Sorry. If they're arguing that like it was just like one of 10 flyers that they could distribute, there's no evidence in the record that they were distributed in the forum. So it could be supportive for LO8. Is the fact of 10 legally significant? I don't think so. But emotionally, yeah. No, that's fine. So it was the third party that requested brochures from CR Varfala. It wasn't CR Varfala saying, "Ooh, they're going to Boston. Let's get on board." Right. So there's that, and the fact that it was a bunch of companies may support the argument that there really was no direct control.
Say though that, Iceland is a small country, but they're choosing this company out of 10. I mean, it clearly must get a lot of revenue to be that noticeable, or
Possibly. I mean, it's all possible.
yeah.
I don't know. Okay, just I'm almost. Let me see if there's any. I have a couple more, and I'll post this on Twen.
Sorry, you said yes, that was.
Well, I think it's. I mean, these are hard cases. These are the hard facts. So I wanted to have a discussion about them. I don't want to declare that everything is like legally significant or not, because I chose the hard ones. Over the 8-year time span, 461 people who made inquiries with Sierra Fala identified their addresses as within the Commonwealth of Massachusetts. Legally significant.
We can present it then.
No, not for LO7. But LO8 might.
What if, does it have to be an 8-year time? Like, is there some point where I can choose to cut it off of being?
You don't want to be manipulative, right? And you have to include the legally significant facts. So, you know, I probably wouldn't present it this way if I represented your side. 460 identified their addresses. Well, it's favorable to you because you want to show direct targeting, right? So, what's the other side saying about this fact? How does the other side respond to this fact? That's possible. That's possible. What else? Yeah, the interrogatories say that they're really not sure as to whether that equates to customer bookings, right? So, but that's legally significant too, to include. Okay. The trial court found that Sierra Fala's website doesn't rise to the interactivity warranted in the exercise of personal jurisdiction. Kind of covered this. It's really the fact that they didn't find personal jurisdiction is legally significant and a necessary background fact. You've got to bring the reader up to speed. But the reasoning of the court is not legally significant of the same degree. Although, now I'm thinking. Keep in mind that for the purposeful availment analysis, the other side, or LO8, can say the trial court correctly found. But they can't say that for reasonableness, because the trial court made no finding on reasonableness. They only made the finding on purposeful availment. So they can't say, LO8 cannot say the trial court correctly found that the burden on the defendant was unreasonable. Yeah, the trial court made a finding on purposeful availment.
Right.
They did not make a finding on reasonableness. They didn't reach that analysis. So it wouldn't be proper to say the trial court correctly found, the trial court correctly found, or the trial court erred, the trial court erred, right? On the second one. Because they made no finding on it. So the fact that they did a purposeful availment analysis could be a necessary background fact. That's the implication of this. Because they didn't reach reasonable, that might be necessary context. And is that good or bad for you? I don't know whether it's here. Because you have to, I mean, I guess it's bad insofar as you have to say, if the court doesn't reach, the court finds no purposeful availment, then they won't reach reasonableness, right? Alicia, you asked me that question, whether that's appropriate to say. Yes, it's appropriate, but I don't know whether it's like either here or there. It's the way the law works, right? Anyway, just okay. So, any questions about selecting facts? I know this is probably raising more questions than it is providing answers, but I think it's giving you an idea about how much energy and time it takes to create the narrative. Thinking about the organization, thinking about the invisible persuasion, thinking about the selection of the facts. That's all I have. Yeah.
Be honest too. You know how I don't remember what it's called, but in the final, we have a list of all the cases we use, their pages.
The table of authority?
Is that the only time that we use a full site for them, or do we use it full site?
No, you have to use a full site the first time it appears in the argument.
Okay.
And every time it appears on a page, it's got to be included in the table of authorities. Even an id is included in the table of authorities. So let's say A Corp appears on page 6 originally, and then it appears again on page 11 and page 12, right? I would include 6, 11, 12.
But you have an example of this post.
There's an example of it. The table of authorities in the template is not automatically formatted. You have to manually change the page references. So I would do that almost last, because any small edits you're going to make could change that pagination, whereas the table of contents is automatically formatted. If you have questions about how to automatically format that. We kind of covered it in both LOs for the table of contents for the projects, but how to do an automatic table of contents and how to update it. But if you have questions about that, and there is a short description of how to do it in the template, let me know. What about questions about oral argument?
If I say defendant,
Nah. No.
I can't say appellate.
Now you're gonna say it because you just like you've like obsessed about it. What else? I think it'll be great. The judges are a very like understanding crew of people, albeit I'm a judge for some of the arguments. So just remember, like, your goal is to be unflappable, right? And that just means coming in with an air of confidence, even if you are dying inside. I mean, it's fine if you're dying, but the goal is to stay present. Try to just stay in your body, because so many people will like dissociate and like. That's what happened to me in my oral argument. Like, I floated above myself, and I remember like words coming out of my mouth, but I don't remember like what I was saying. It could have been like blah 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 blah, blah like the teacher from Charlie Brown.
Yeah. Are you recording?
No, I'm not. I thought about it. I mean, why? Do you want it recorded?
No, I'm just wondering because you're not one of the judges.
I'll be in every oral argument.
Oh, okay.
Yeah. I'll be grading or assessing in every oral argument.
Okay.
Yeah. There are often times when I've wanted to record. Many times. Now there is an open session, a reserved argument session at the very end. That's a surprise.
In CCC.
No, at the very end, so Thursday.
Okay. And so everyone's going to that?
No, not everyone has to go to that. I haven't decided yet. Okay, I'm being very nebulous about what's going to happen there. No, absolutely not. But there may be an opportunity to argue again. That's not really. It's more like a showcase kind of thing.
Oh, okay.
Yeah. But there's certainly going to be times like to practice. I don't think anyone's going to think you did. I don't think anyone's going to think you did really badly, and I think you're not going to think you did really badly. I think you're going to think, I can't believe I got through that. Honestly, I do.
Mine's gonna like 6 hours.
You'll be fine. Just remember, just remember that nerves are a good thing, and they are, and just project an air of confidence, even if you're dying inside. Might be. I mean, I remember dying inside and I was a performer, right? And so there's a very big difference between performing on stage with a script and making an argument on your feet extemporaneously. There's a big difference in the feel of that. But you're not going to have a bench I don't envision having any bench unless you're combative or like inaccurate or untruthful, really. You're not going to have a bench that attacks or like is like angry, right? So I think you'll have a very like a soft but hot bench, meaning like nice but lots of questions. Okay, Rachel, a question?
Wait, okay, so
So it is assessed, and I do put points on the assessment sheet to show you the difference between your practice round and your final. If you do really well in the oral argument, like really stellar, you've made great improvements, I envision maybe mentioning it in your eval. If you made good showing, but like your improvement wasn't. I don't envision. I would never say. I don't think I would ever say in eval they bombed oral argument. I just don't. I don't envision saying that. This is the sort of. I do think of this as the icing on the cake for the year. So it is a rite of passage. But if you do really well, I envision it sort of bolstering your eval. Yeah.
I then respond to it or move on?
Sure.
Okay.
Sure. Yeah, that's totally appropriate for rebuttal. If you think that but just be careful with a rebuttal because oftentimes like we find things that we want to poke holes in, but they're not the most important things to poke holes in. So just like in your sort of prioritization of your points for rebuttal, just keep that in mind, right? There might be more important points to rebut. But oftentimes people will sort of glom on, oh, that's not true, but like it may not be legally significant or to the court to make that draw that distinction. Yeah.
So we're doing it in the moot.
No, we're doing it in 104.
Oh, we're not doing it. Oh.
We don't have the moot court room. I think we have 104. Did Tess not say that? I think it's 104. So it's a smaller room.
Is that one by no, it's not.
It's by the courtroom.
Yeah.
That one that we went to after.
Mm-hmm. Mm-hmm. So I haven't gone in there to see how it's going to be configured. I tend to like more room between the judges and the oralist rather than less. I think less is like straining. Although I was in a courtroom recently that was really close. So, I mean, it can happen. Other questions about oral argument? It's going to be awesome. Can you see how the preparation for oral argument helps you in the writing of the brief? Mm-hmm. Like in the knowledge of the facts and how, like, what the other side's arguments are. So I'm hoping that after your arguments, you're really going to be able to, like, reinvest in the brief and make it more nuanced and more richer, right? Okay. Thank you very much.
Thank you.